Ladies and gentlemen, welcome back to the next session of AIAC DNS Forum 2022. And this session is entitled Privacy Trend and Domain Name Dispute Resolution. This session will be discussing the type of domain name dispute resolution and the key difference between MYDRP and UDRP, including the processes that involve in MYDRP and UDRP. Latest trend on UDRP and MYNIC cases filed with AIAC settlement and why DNDR procedure are better than court proceedings. Before we begin, I would like to highlight that you can win prizes by attending the forum session. Here is how it goes. We need you to attend all the forum session, engage with the speaker throughout the Q&A, and visit the virtual booth to collect the points. The top 10 participants who collect the most points will receive an Amazon gift card worth USD 50 each. Our moderator for this session will be Yo Yiling from MYNIC. So welcome, Ms. Yo, and the floor is yours. Thank you.
Thank you, Amir. Good afternoon, good morning, good evening to participants from all over the world. Welcome to the Asia Pacific DNS Forum that's hosted by MYNIC and ICANN. I'm Yiling, the legal manager for MYNIC Malaysia, and I'll be your moderator for today. The inaugural Asia Pacific DNS Forum was officially launched on the 29th of March and has started on the 30th of March. We are into day 3 of this forum, which is today, 1st of April, of Friday. Today's session is on privacy trends and domain name dispute resolution. So thank you for taking the time to join us this afternoon. We have an interesting panel lined up who will be sharing the latest developments from their respective organizations. So let's welcome our first speaker, Ms. Radine McGarry, who is the Vice President of Two Cows Registry Services. Two Cows was formed from the acquisition of registry business and assets of UNR Corporation, formerly Uni Registry, where she was UNR's Chief Operating Officer. Prior to the UNR position, Radine was a key member of the Central NIC registry team, managing its policy, legal, and CCTLD practice. She has been in the domain name industry since 2001. Ms. Radine is trained as a barrister in England and Wales, and is also a licensed California attorney and a certified practitioner of data protection. She will take us through privacy trends this afternoon. Over to you, Ms. Radine.
Good day, everyone. It's morning here from Europe, and I'm happy to be here. So welcome to my session. I'm going to talk today about privacy trends in the Asia Pacific region. Shall I share my screen and offer you my presentation? 1 second. And oops. 1 second, sorry. Okay. There we go. I hope you can see my screen.
Yes, we can see your screen, Radine.
Okay, thank you. And I'll just move to the next one. Just a word about Two Cows Domain Services. I've recently joined Two Cows as part of the UNR acquisition, as Yo has explained. Two Cows has a 22-year history of registrar services, part of Open SRS, EPAG, and ASCIO and Hoover. It's now the second largest domain name registrar by volume. We have 26 million domains under management, and its distribution network exceeds to over 36,000 resellers, and we operate in over 150 countries across the globe. Registry services was from the original UNR one, and we have a number of clients, and we're seeking to grow the registry backend. So I wanted to talk today about the privacy trends around the Asia Pacific region. And a few years ago, the big GDPR came to the forefront of everyone's minds. And wait, this is not the correct slide. Let me just exit. Yeah, this is a bit of a mistake here. Let me get out. Apologies for this technical issue. 1 second. It's the problem when you have more than one. I want to get this one where it's the final one, or if you can share the final one. Again, apologies for the hiccup.
Rudy, I'm so sorry to interrupt, but I think your slides are not in full screen mode.
Okay.
Yeah.
Let me see what I can do. Again, apologies, everyone. Let me try and exit.
It's that small little icon there at the bottom, Rudy.
Wait, if I stop sharing, right? Having problems again. This we did the test and it was all working fine.
Yeah,
and then I've uploaded the wrong one. So again, apologies. If you can just bear with us for a moment.
You can just move your arrow to the bottom, just right at the bottom there.
Okay.
A little bit to the right, a little bit to just at the bottom, a little bit more to the right. That small little icon is a small little icon there that's next to because we're seeing it in the middle of the screen.
Yeah, but I just need to exit this. I want to get the correct one because this is the wrong slide. And that's the problem. Let me stop sharing and try again. That's different, the wrong presentation.
Trudine, do you need my help to help you share the screen, to help you share your slide?
Yeah, I can't get the right slide if I stop sharing.
Let me try and help you out there.
If you could upload the correct slides.
Is this the one that you're looking for?
Yes, that's the one.
That's the one, yeah? Okay, so you just present.
Yeah, again, apologies to everyone. Obviously, I'm not a tech person. Well, so we can go to the next one, please. If you can manage the slides, we can move to the next slide. We can start to the data privacy one. There we go. I wanted to mention about explaining how GDPR became law and everyone's focus, that's still showing on the, it's not in full screen mode. There we go. Again, apologies, everyone. So I wanted to talk about, where did data privacy come into the forefront and why it's important. And basically, GDPR moved from being part of the conventions. It was then a directive. So each state within the European Union set up their own laws. And then it became a regulation, which meant it had direct applicability in 2018. And the headlines at the time were about the the headline grabbing, 20 million fines, 4% of global revenue was what everyone was concerned about. And now suddenly all the requirements and all the effort on compliance that was there before became more important for people to give it attention. And this became, and it still is, an area of concern for ICANN and the registry and registrar communities to make sure that they're compliant with data privacy. And like I say, everybody was afraid of the fines, and now it's 2020, a few years down the line, and we're seeing some of those fines take effect for non-compliance. I'm not going to read through all the cases, but I wanted just to highlight a few, and the recent ones. For example, Google in January this year has been fined 90 million for failing to put the correct cookie consents on its YouTube channel, and another 60 million euros for its website non-compliant cookies on the search engine site. British Airways had a data breach where customer details and names were harvested, and the hack was found out to be the result of their negligence and not putting into place the correct efforts and the correct compliance efforts. And they did see that once they put more mitigation efforts into place, then their fines were reduced. Again, Amazon was fined for cookie consent. WhatsApp was fined for failing to explain its data processing practices in its privacy notice. Meta and Facebook were fined by the French Data Protection Authority this year for cookie consent breaches. And recently in March, they've found a further 12 breaches by the Irish DPC for 17 million. And they just failed to implement appropriate technical and organizational measures to protect EU citizens' data. And since May 2018, both between the UK and the EU, there have been over 900 fines issued. We can go to the next page, please. And on the next page, I've highlighted, we lost the screen. Oh, next page. If we're still having problems with the screen, I'm happy I can just, can we move to?
Yeah.
That's the thing that didn't happen in rehearsal. I had no problem sharing my screen and the correct one. And there were a couple other cases. Yeah, that's fine. Both Marriott and H&M, which I won't bother reading out the full extent of those, but they just highlight other errors of failing to safeguard systems, failing to use, encryption in the case of Marriott. And in H&M, it was found just to have monitoring employees for sick leave were found to have not been handled in an appropriate manner and failed to minimize data. So all those cases basically reflect breaches of the 8 principles of data protection law of various levels. We can go to the next slide. So the focus of this talk today, next slide, please, is the data privacy in the Asia jurisdiction. And what we can say, can you move to the next slide, please? Can we move to the next slide? Yeah, thank you. So back in, if we go back through the recent years, before 2010, only 6 jurisdictions had comprehensive data privacy laws. And between 2010 and 2020, we've seen 13 more countries enact new data privacy laws, and we've seen 7 amend existing laws. Currently, there are 8 countries that are working to enact new privacy laws in the near future. And in the longer term, we can expect to see further developments in Australia, Hong Kong, Malaysia, and Vietnam. The newest laws in the area can be found in Thailand, which are due to come into force in June 2022. It's been delayed, the actual implementation, I think, because of the COVID. China has had new laws, not just on data privacy, but on data security under the new cybersecurity laws. Updates onto existing laws, which can be found in Japan, South Korea, New Zealand, and Singapore. And Indonesia is also adding new laws, and we'll come to those later. Next slide, please. So what about all these laws? How do we manage compliance? Some of the laws of the region share some core data protection elements that are found in the GDPR, but each have their own specific rules and reflect the different legal systems of each country. So developing a regional or a global privacy program, is and I believe will continue to be challenging. So if we look at the major areas of the data protection, if you look at the processing scope, most of the Asian regional laws refer only to in-country processing. Again, this is fine if you're a business operating in only one country, but as we heard yesterday in the last session of the day, the MYDRP, Mr. Madir, was talking about what's happening in Malaysia and about the potential increasing the trade and cooperation across the whole region, which is all very exciting potentials and future ahead for the region. But this does make it complex if you're going to be working across different markets and serving customers throughout the region. So when you look at the extraterritorial scope of GDPR, which there are 5 countries that have similar rules about processing and moving personal data across boundaries. And those are Australia, Japan, New Zealand, the Philippines, and Thailand. And on top of those which have, restrictions on data, international data transfer, some confine themselves to just processing data in country. And then in China, under their new cybersecurity law, again, has a data localization law, which basically means that critical infrastructure has to be stored in China. They have various cyber sovereignty goals, which again have a different dynamic compared to the other laws. And next slide, please. So in the what is easier is if there is adequacy. And what does adequacy means? It means that if one jurisdiction recognizes adequacy, that the other jurisdiction has a privacy law which is similar and believes to have adequate protections for citizens. And that allows for lawful international data transfers. Under the GDPR, there have 14 countries which have been deemed to have similar equivalency in terms of privacy laws. And in the region, there's 3 that have it: Japan, New Zealand, and South Korea. South Korea has just in December this last year, 2021, was awarded adequacy. Which countries are seeking an adequacy decision? Well, Australia was considered back in 2001, but there were found to be 8 areas of deficiency. Taiwan has applied, and they're in public consultation with further changes enacted in 2019, and it continues to pursue a determination. And so what is the process, and why aren't we seeing more countries go through it? Well, the process takes several years. And it's not an easy approval process because the Commission, the EDPB have to approve it, and each of the member states all have to approve. So for some countries, it may just feel like too high a bar in which to pursue it. Let's go to the next slide. Yes, cross-border transfers in Asia. So 15 countries impose cross-border transfer restrictions. And the reason for which transfers can be made vary, and that can depend upon consent, it can depend upon adequacy, it can depend on legal requirements or contracts. And within the Asia region, there's no country has agreed adequacy with each other, but New Zealand has model contractual clauses. So those can be used with other countries in order to create a lawful transition. And then there are other countries which have, the laws are basically silent. So in Hong Kong, for example, there's no restrictions for cross-border transfer. Next slide, please. So what are the legal basis for, excuse me, what are the legal basis for processing? Most of the laws don't use the principal one that we rely on in the GDPR jurisdiction, which is using legitimate interest. So it becomes a question of consent versus legitimate interest. And that has, again, a lot of implications on how data is managed, how systems are designed. If you're relying on consent in which to hold and process data, that party can always withdraw that consent. And then you have to design and implement systems to allow that data to be deleted or removed. Where you can rely on legitimate interest, for example, you can retain information because you have a legitimate interest in case that person comes back and complains or there's a lawsuit. So it does make it a lot easier in the GDPR jurisdiction where you can rely on legitimate interest. Then you have a jurisdiction where it just doesn't cover that, it's only consent. And then there's a key principle of the rights for erasure. Now, most of the jurisdictions have this right of erasure. The consent withdrawals, and the party means the data subject can say, well, then you have to, delete my data. And again, for our compliance, that has its operational impacts, especially with, if you're running a large registrar or a registry, making sure you can delete just that one person's data through all your systems. Anyway, most jurisdictions, you have this right. And then only 4 countries, though, provide data portability rights. And that's China has it in the privacy standards. The Philippines has data portability. Singapore and Thailand have this right. What does data portability mean? It means that a data subject can say, I want all the data that you have on me, and I want to transfer my data to another provider. And that, again, creates operational complexities and difficult for everyone to comply until there's set standards of, how is that data formed and managed and processed and then delivered to another provider. Maybe we're lucky because not every person knows that they can have their data transferred and don't make these requests. Registrations with Data Protection Authority. Again, in certain jurisdiction, you have every business, everyone who collects data has to register. In some countries, like in the UK, we actually have to pay and register a certain amount to the Data Protection Authority. But in the Asia Pacific region, registration with the Data Protection Authority exists only in Malaysia and Philippines. I don't know if you have to pay anything in those jurisdictions, but you do have to register. Breach notification requirements. Most countries require notification in the event of a breach. Others require that if you have a breach, what do? You just notify the people who are affected by the breach. Some of them have particular time limits. Again, if you're trying to embrace a multi-jurisdictional strategy and you're operating in lots of different countries, you have to be aware of what time, if you have, what time zones, what time limits do you have, sorry, in which you have to act and what that means, because some will just say more vague, you have to notify the breach promptly or without delay. And then other countries say you have 72 hours. again, the clock ticks from the moment of discovery of the data breach, and then you have to make sure that you comply. And all the mitigation efforts are important to avoid any potential fines, or again, just to be in compliance with the laws. Next topic is data protection impact assessments. Most countries don't require these. These are a requirement of the GDPR, and it means that you have to do an assessment of all your data and keep track of it in order for you to be seen to be compliant with the data protection laws. But DPIAs are required in Singapore, South Korea, and the Philippines. So what have we seen with enforcement in the region? We've seen enforcement in the region in South Korea, Japan, and Australia. They have been focusing on enhancing private sector security practices, because obviously the whole purpose of the data protection laws are to protect it. And nowadays we live in a world where there are hackers, and how do you help them? And so there's been complementary laws on cybersecurity laws and training. Requirements for a data protection officer. So in many jurisdictions, there is a specific requirement for a certain type of company, depends on its size in some jurisdiction, for having a data protection officer. And in those countries, it's Japan, South Korea, New Zealand, the Philippines, Singapore, and Thailand, all require a data protection officer. In China mainland, there is a new kind of a chief data officer requirement. That's called a responsible person for data protection, but it has a much wider sphere. It's not just about protecting the data within an organization, but it's about has a promotional of economic digital markets role. It has a innovation of data management and integration role for data governance, and a supervision aim, and a talent building role. And this is under certain parts of China, they're doing some special markets of trying out what this chief data officer role would be. And they have a very independent role outside of the organization with, like I say, these other roles. New laws. In what's really happening, what's on the forefront to keep on your eyes out, Indonesia, which is one of the fastest growing digital economies in the region, is very close to having its first personal data protection law. Indonesia suffered a massive personal information breach itself, with over 279 million people, or had a major hack into the national insurance scams, which, you know, again, helped highlight the reasons why we need to have the laws. In India, in 2019, introduced the Personal Data Protection Bill, which is under review, although we don't know when that will be adopted. Hong Kong has the Personal Data Privacy Amendment Ordinance, which is coming into force in October 2021, and introduces new offenses of doxing and corresponding penalties. Again, I didn't know what doxing was. I hadn't heard of this. This is exposing or disclosing personal data without consent, with intention to cause psychological harm. And they've had at least one fine, and that has a potential for fines. I know we're coming to the time, so if you'd like to read more about the overview of data protection in Asia, there's a list on this page of the different privacy acts and laws. And on the next, we can finish, there's some resources that I did for my research, and I'm happy to answer any questions. And again, apologies for the beginning with the issues on presenting the wrong slides.
Thank you so much, Radine, for the interesting presentation. So we will basically be taking on questions towards the end of the session. So just so hang in there. Basically, I'm sure attendees there's much food for thought for them to digest, and we will basically be sharing the Q&A session with all panelists. So let me welcome the second speaker for the session. Our second speaker is Mr. Dennis Chai. He is a council member of the Asian Domain Name Dispute Resolution Center, AIAC, and he's also the president of Policy and Compliance at Internet.Trademark Organization Limited. Dennis is currently being listed as a domain name panelist by arbitration bodies in Hong Kong, Beijing, Seoul, and Malaysia, and he has decided over 30 domain name disputes as sole panelist, presiding panelist, and co-panelist. Mr. Dennis Chai will be presenting on domain name dispute, resolution, observations, and avoidance. So Dennis, over to you.
Okay, thank you, Elaine. Okay, please let me find my PowerPoint to make sure it is the correct one. Can I have the control of the PowerPoint? Do I need to yes, do I need to share, right? Share
yes,
my
you can. Yes, you can share screen, Dennis.
Okay, let me share the screen. Sorry, it took a little bit. I can't see the button. Let me try.
Dennis, let me help you there with sharing the screen. Yeah, just let me help you there.
Mistakes, I cannot see the sharing button. It's weird. Yes, I found the share screen.
Hi, Dennis, I've shared the screen.
Yes,
yeah, can you see it?
Yeah, I'm also sharing. Can you see my screen?
Yes, we can see it.
Okay, let me F5. Let me try. Let's see. Okay, does it work?
Yes, it works.
Okay, thank you. Thank you, Elaine, and thank you. Sorry for the hiccup. I'm Dennis Chai, the council member of DNDR. First, let me thank the organizer for including me as the speaker. It's my great pleasure to join and share my some observations on domain name dispute resolution. First, let me introduce to you about ADN-DRC. And the Asian Domain Name Dispute Resolution Center is an ICANN accredited dispute resolution provider for UDRP, URS, and other dispute resolution procedure as well. It has 4 offices located in different major cities in Asia, including Hong Kong and Kuala Lumpur, Beijing, Seoul. And we have 4 offices operated by leading arbitration center in Asia. And so this is a very busy center as domain name disputes keep arising. now let me talk about domain name dispute. I'm aware that some of the other speakers may mention that. Just want to define the domain name dispute here. We are discussing about refers to the domain name or the dispute or domain name contract between the registrant and the trademark owner, and which is concerning the three elements as listed in the slide here. The first element is concerning about the domain name, whether the domain name is identical or confusingly similar to a trademark or service mark in which the complainant has right. And the second argument arising in the domain name dispute is about whether the domain name registrant has right or legitimate interest in respect of the domain name. And also the last one is the domain name has been registered and also is being used in bad faith. So this is three typical elements in a domain name dispute under the UDRP. Of course, there are other types of domain name disputes, but we focus on the trademark-related domain name dispute, which has the largest volume in the world, and ICANN UDRP has been a very effective tool for resolving such a dispute. Now let's move to the question: who filed most of the domain name dispute? And here comes the industry breakdown, showing that the major industries who cares about domain name, and they engage lawyers and file domain name dispute with a dispute resolution service provider, such as DNDR, to recover the domain name which has been registered by someone else in bad faith. So this is the industry. The first industry is banking and finance. So it is very easy to understand. Banking and finance corporation, they're concerned about the security and also the counterfeiting or the fake websites. So these would be very serious matters to banking and financial industry. And the second one is retail and fashion and biotech, pharmaceutical. So these are the major industry they cares about domain name. Of course, food and beverage, heavy industry, entertainment, electronics. So this is some figure for your information. Just let you know that domain name is getting more and more important. And domain names are also critical in anti-online counterfeiting activities. Online counterfeiting has become a very serious issue around the globe, and a lot of people in different communities, they jointly take actions to combat or to tackle the online counterfeiting. One of the efficient way is to take down the domain name. Then you can have a website having counterfeiting products sold online to down. So this is domain name taking down is a very efficient way to tackle the online counterfeiting problem. So this is a picture. Some statistics shows you that Europol takes down over 33,000 internet domain names for concerning the selling counterfeiting goods. So how to resolve a domain name dispute? Actually, some of the other speakers have mentioned litigation, legal proceedings, and one cheapest way is negotiation. But this is not an effective way in terms of domain name dispute resolution. But still a lot of people using how to say negotiation. In fact, this is you just negotiate with the domain name registrant who register your domain name and trying to get the domain name back by negotiation. Of course, there are conditions that both parties need to reach. Maybe you need to pay the registrants certain price to settle the dispute, but it's not going to work if the respondent if the registrant is a typical cyber squatter. They will use your money to register more of the domain name comprising your brand and trying to sell it back to you again. So negotiation may not work in domain name dispute resolution. So the second approach is to sue the respondent, sue the domain name registrant in a court, in a competent court. But the problem comes when we talk about domain name registration. It may involve different jurisdictions. The registrar may be from a third jurisdiction. The complainant is in one jurisdiction. And the respondent, the domain name registrant, could be in a place that you have no idea. And so commencing the court case to litigate the domain name dispute could be challenging, but sometimes not feasible. And of course, when talk about the enforcement of the court judgment concerning a domain name, it could be problematic. And there is no guarantee that you can have a court decision enforced outside one jurisdiction. So litigation for resolving domain name dispute is not so effective. It could be very costly because this is an international case, very likely in the domain name world. So what happened is it is good to have ICANN UDRP because UDRP, when it was launched in 1999, it has become the most effective in terms of cost effective and time effective to resolve domain name dispute. It has now been used widely by trademark owners in the world to recover domain name registered by typically by cyber squatters. So this is 3 ways of resolving domain name dispute. And one of the beauty of ICANN UDRP is that it has a very efficient enforcement framework of the dispute of the decision. Once the provider, the dispute resolution provider, notify the registrar that the decision has been made by a panelist, the registrar shall implement the decision after waiting for 10 business days, and if there is no appeal to the court on the decision, then the decision will be implemented. So it's a very efficient way, and it is only takes about less than 60 days to complete the whole procedure. And also the cost is very effective. It is very highly affordable. It's about $1,300 per case. Depends on the numbers of domain name involved in one case. So here comes some real case examples showing that how to resolve a domain name dispute. It is an ADN-DLC case by the Beijing office. It's concerning an hydraulic pump, a very famous brand in the industry, but I'm not familiar with the brand because I'm not in a heavy industry. But the domain name dispute panelists found that counterfeited product or unauthorized product are being sold on the website resolved by the domain name. As a result, the panel ordered transfer of the domain name back to the UK complainant. So this is the typical case, and more cases is coming. And this is a case decided by me as a panelist. I learned that there is it is concerning an online payment platform, very famous online payment platform, versus the registrant in mainland China who registered the domain name comprising the brand and with some changes. Of course, it adds Sino to the very famous brand, PayPal, and the top level domain is .cn. So this happens commonly in the world of domain name registration. And I've found that the brand has or the complainant has never authorized the registrant to use the trademark for this purpose. And the domain name also linked to a website, very active website. It is has a lot of function here, and concerning online payment, it shows that there is a wide range of collaborating bank with this website. The users can pay online through this platform resolved by the domain name. Of course, it's very misleading because it comprises other famous brands trademark in the domain name. So I make a decision to order transfer of the domain name back to the complainant. And actually, both sides of the dispute, they are represented by big law firms. It's a very contentious case indeed. more interesting cases here. When we talk about domain name dispute, people would think of famous brands, luxury brands, but indeed, arbitration center itself can be complainant in the domain name cases. In this case, HKIAC, the Hong Kong International Arbitration Center, recover hkiac.org through WIPO proceedings. So this is quite typical. And not only HKIAC, and in 2013, 5 major arbitration centers, they jointly filed a domain name dispute with WIPO and recover 17 disputed domain names registered by a Canadian law firm. So this is a very interesting cases. And I'm also aware that some of you may have heard about domain name and trademark. I'm not going to repeat or go into the very detail. Just want to highlight that domain name is functioning as an online trademark in the time of the internet, serving as an key identifier to distinguish different sources of the product and services. So this is a time of domain name, and trademark is still important, but you may need to register to get the protection of the local law. But for domain name, you also need to register. But registration of the domain name may not get protection of the law, but it is very important for business people to connect their clients to their website. So here's the table telling the differences or the common grounds between the two. I would also like to share some observation on domain name disputes. The first one is, under the COVID-19 pandemic, we have seen increasing number of domain name disputes arising. The reason is very straightforward, because a lot of social restriction measures we are now facing. We spend more time on the internet. Everything is happening internet. And DNS, we have learned that it is important to have a domain name to make the internet function properly. So domain name registration will increase. When the domain name registration increase, of course, domain name dispute will increase as well. So this is the one observation. More cases coming up. The second one is, you may focus on who win the domain name cases at the end. HKIAC statistics shows in 2019, over 97% of the cases of the domain name cases resulted in transfer or cancellation of the domain name. So that means the complainant will prevails in the domain name cases is very common. So why this is so easy to win a case? Because there's a lot of cases are straightforward cyber squatting cases. And the third observation is that domain name dispute often involve famous brands. As a use, if your brand is not famous, it will not attract cyber squatters' attention to register your name as a domain name. But if you are a famous brand, you have to keep watching who have what are the names that's been registered by someone else. And lastly, my observation is domain name dispute will arise repeatedly. So this is a good thing, maybe a problematic thing, because internet is free and open. Most TLD operators do not impose a verification process for domain name registration. Anybody can register any name he wants, as long as the name is available. And of course, except for other verifying domain name, which we will introduce a little bit later. So famous brands are frequent users of domain name dispute resolution services, because of 3 observations I have mentioned. They have to keep watching the domain name registration and keep filing domain name dispute to recover the concerned domain name for business purposes or for brand protection purposes as well. Now we shift the topic a little bit to the detection of domain name dispute, which is quite relevant to domain name dispute resolution and prevention as well. in the world of the internet, you are more familiar than I do. We have over 300 million registered domain name, and every day a large number of new domain name registered. And but of course, you can imagine the larger percentage of this newly registered domain name may have infringed other brand owners' legitimate interests. So this is a very interesting point. You have to keep watching the internet. Here comes an example of the Winter Olympic winner, Eileen Fu's name, when he won the champions, but on the same day in the internet, hundreds of domain names have been registered concerning his personal name. So this is the example showing that how her name has been registered under different top-level domain name within a very short period of time. Now, we also talk a little bit about on verifying domain name. I mentioned that most of TLD does not impose an eligibility requirement for domain name registration, but there are few domain name, top-level domain names that has implemented some types of registration restriction. And in an ICANN survey in earlier days, ICANN survey reveals that consumers tie registration restriction to trust. And in the survey, over 70% of the respondents favor some level of restrictions because consumer may think the domain name top level with restriction may be safer or less likely to go into a wrong or misleading website. So this is reasons why we need to rethink putting up some registration of domain for domain name registration. And in the industry, there are some leading law firms have certain write-ups on verifying domain name. For example, the Deacon's law firm wrote an article for the Dog Bank and also for Dog Trademark, and there is a leading law firm in Shanghai, an international firm, put up an article in Chinese concerning the Dog Trademark domain name registration here. So now here comes the table of the major verifying domain name. We have a short list of top-level domain name here, and I did a research on the registration volume and eligibility restriction, and also registration fee, and giving you some example, and found that this domain name has been increasingly used. But of course, in terms of the registration volume, I don't think they are successful in comparison with the big, the major player ones, because they are implementing certain kind of restriction to narrow down their business scope. And of course, this is the domain names are quite costly in comparison with the others. But it is these domain names are claiming they are safer than names, make sure that they can provide better protection for consumer and brands. So I won't go into the very detail. In short, we have the dog public interest, dog government in Chinese, dog trademark in Chinese, dog bank, dog insurance, dog pharmaceutical. And for the first one, the dog public interest, it only make it available to charities. The dog government make it available to government department in China. And for the dog trademark, it only focus on make it available to or dedicated to the registered or unregistered trademark owner. That means there is no cyber squatting happening within the dog trademark zone. For the bank, dog bank, it's only allowed banking institution or association to use and register. Likewise, the insurance, pharmacy, they all have their own eligibility. So this is a new idea, but it could be a tough business for them because they restricted themselves to a certain scope of targeted audience. So this is this trigger myself to rethink the domain name registration. We have to continue the free and open for the majority, but we have a minor one, which is ties closely to the domain name verification, and to focus on domain name dispute prevention and avoidance. And I think this is an interesting development, and just for sharing. And the last point in my presentation, I would like to touch a little bit on the brand localization and Chinese domain name. As I see more Chinese domain name are involved in domain name dispute, here comes some example. And like this is big brands again, Alibaba and Taiku and Baidu as well. They file domain name cases with ADN DRC to recover their Chinese domain name. That's the IDN domain name as well. For ADN DRC, we also handle quite a number of Korean language domain name. That means IDN is getting more popular, but it still takes time to get it to the level of the English domain name. But it is increasing. The use of the Chinese domain name is increasing. And in the meantime, the China authority also committed to promote domain name. And recently they have a regulation or policy passed to further promote or to enhance the environment of the Chinese domain name. I'm sure the topic will be covered by other capable speakers in this forum. I just want to, from a dispute resolution perspective, Chinese domain name are getting more valuable and could be the subject matter in domain name dispute. And in the National Committee of Chinese People Political Congress also received a proposal to enhance the environment of Chinese domain name as well. So here comes my summaries. I think domain name dispute continues to play an important role because the majority of the DLD is free and open, first come, first serve, without verification and restriction. And that's why domain name dispute will continue to increase. And this will trigger domain name dispute detection technology being used for detecting or monitoring the infringing domain name registration. And lastly, people might think about to reduce the domain. In one hand, you have to use legal weapon or technology to tackle the domain name, the infringing domain name registration. But on the other hand, you might need to use a safer, verifying domain name to help reduce the misleading impact on the brand for better brand protection, and also for dispute avoidance purpose. So here comes the end of my presentation, and very short, and I would like to give the floor back to the moderator and other speaker. And thank you once again for having me. It's my great pleasure to join.
Thank you very much, Dennis, for the very insightful presentation from a perspective as a panelist from the Asian Domain Name Dispute Resolution Center. Next, third and final speaker for this session is Mr. Paddy Tam. Mr. Paddy is the product manager for CSC's brand protection business in Asia Pacific. He has over 10 years of brand protection and dispute resolution experience, specializing in online brand protection and anti-counterfeit services that help clients detect and remove online threats, brand abuse, and fraud. He is also a domain name panelist that's credited with the DNDR, the Asian International Arbitration Center, the Hong Kong International Arbitration Center, and the US National Arbitration Forum. Mr. Paddy's topic is on organized cyber squatting and domain name dispute resolution. Over to you, Mr. Paddy.
Good afternoon, everyone. Can you hear me?
Yes, we can hear you, Paddy,
Thank
loud
you.
and clear.
Yeah, thank you. Let me share my screen. Okay, just making sure all of you can see my screen sharing the slide.
Yes, we can see your slide.
Thank you. So thank you, everyone. And also thank you for the other speakers sharing about their insights on the data privacy as well as domain name dispute resolution. And my part, I will talking about organized cyber squatting and domain name dispute resolution. And some of the part, I believe, will echo what Wayne and Dennis mentioned before. So let me get started. So CSC, we have recently conducted a study on the impact of COVID-19 on the internet content. And there it includes a range of online channels. Of course, the domain name registration would be the main focus. And the study was conducted by using our CSC proprietary domain set software as a service cybersecurity platform. In the study, we have found that more than 478,000 domain name registered related to the COVID. And interestingly, we noticed that the surge in the activity is in sync with the real-world events. In the next slide, I will show you a graph, which is coincidentally that the number of registration is the same as the real-life events. At the meantime, the new domain registration also provides risks to various variety of forms. For example, it could harm the supply chain. They could also be used for sending phishing email and organized fraud. Like having some ransomware attack, business email compromisation, and also, just like what Dennis mentioned, that some of the domain name could be used for brand abuse, like counterfeiting. It is very important for the brand owners to take care about to pay more attention to the domain security. Here is the chart that we drafted based on our research. You can and it was conducted in the past 2 years, starting from January 2020. You can see that in the beginning of 2020, the registration increased steady, and mainly started from the declaration of pandemic by the WHO, and then it goes to the peak in April 2020. That the first vaccine human trial begins, as well as the some treatment provided by different pharmaceutical companies and also the doctors. After the peak and the domain, there are still a high number of domain name registration every day, but there is a downward trend afterwards. And however, at some particular time, the daily registration increased suddenly. For example, in December 2020, when FDA approved the first home-use COVID-19 test kit, there are over 2,000 domain names related to COVID registered on the same day, and I believe most of them would be related to test kit or similar wordings. And recently, after we noticed that there is a new variant called Omicron, there's also another spike of the domain name registration in late last year. And there is also an observation that not every single domain name will be renewed after 1 year, and most of the domain name that I would guess that for those has been used for launching phishing attack or sending phishing emails may not be renewed after the first year, and the infringer, they may pick another a suitable domain name to launch another round of attack. But some of the cyber squatter, like the domain investors, they may wait for the brand owner to acquire their domain name. And so some of the domain name has been renewed and some of them has not. And in April 2021, sorry, and there's the cross, and it's the first time we observed that the number of dropped domain name exceed the new registration. As to the type of domain name registered, the GTLDs are still the main, contribute the main of the registration. It would be around 73.8%, and some CCTLDs and new GTLDs are also chasing, which is about 10 or 12%. We also note that there are some other type of domain name. I personally call it as a subdomain, or we can also call it as a second level domain, that it could be registered or created by the owner of a domain name. For example, a blogspot is .com is a very famous blogger page, and WordPress is another one that is very famous for the user to create a handy website. So the users may simply register a domain name, register an account with those providers, and they will be given a subdomain. With that, some of the infringer, they may prefer to use such a domain name, probably because that those providers, they have a very high reputation, and they may have a better effect in the search engine optimization. When we deep dive into the branded infringements, for example, there are several pharmaceutical companies that they are producing vaccines, for example, Pfizer, BioNTech, Moderna, Johnson & Johnson, or the top health organizations like FDA, CDC, or WHO, the World Health Organization. Then we observed that there are more than 350 domain names registered since 2020, and most of them were not registered by those bodies. And we also noticed that the majority of those domain names resolved to pay-per-click site or simply resolved to no content. And of course, in the WHOIS, I would say over 90% of them are either redacted or hiring a privacy protection service. So from the privacy perspective, then I totally agree that it is very good measure to protect the ordinary users or brand owner. But in some case, for example, cyber squatters, it could provide another layer of protection to them and bring in some burden for the brand owners to find out who's the cyber squatter and how should we find out the other related cyber squatting domain names. And we also noticed that MX record are active in some of the domain name, and we all know that MX record is the one supporting sending email. So potentially some of the domain name could be used for sending email, phishing email. So here comes some options for enforcements. For example, if we only want to remove the infringing content, we can consider takedown. But of course, takedown is just could be the quickest one, but it's not a permanent resolve. So ICANN launched the URS Uniform Weapon Suspension System a few years ago, and then which allows the brand owners to file a complaint with the arbitration center to suspend the entire domain name. But there's a drawback that it only applies to some to the new GTLDs and some CCTLDs. And UDRP and some country code dispute resolution policies that could help the brand owner to recover the ownership of the domain name after filing the complaint with arbitration centers like ADNDR, AIAC, etc., etc. And some providers, they have shown some recent case related to the COVID-19 infringement. And I have personally handled a case for a very famous brand in AIAC that the brand has been used to register domain name plus bank and it is a .com domain name. And then the infringer has launched a website promoting a vaccine investment scheme, then I would say it is highly suspicious, or even is a fraudulent scheme, because they are promoting the scheme to say there's a very generous investment outcome after you send over some funding to them, and then you can just like investing a stock or funding, then you can get a very generous outcome. And we decide to file a UDRP complaint with the DNDR, and then within 2 months we got a favorable decision, and then you can then proceed to transfer the domain name. So Dennis has already talked about some basic features of UDRP, and here maybe I can supplement a bit on the comparison between UDRP and .my DNDR, the domain name dispute resolution. So unlike UDRP, .my can only apply to .my domain names, and within the dispute resolution policy, there are some similarity and also some difference. For example, the first element is the same, that basically the domain name need to be identical or confusingly similar to the trademark owned by the complainant. And the second element is removed, or I would say it is moved to under the third element, because from complainant perspective, they may only need to prove that the registrant has registered the domain name in bad faith. However, if there's any response filed by the respondent, then the legitimate interest on rights could be a defensive argument under the bad faith elements. And another difference between UDRP and .my DNDR is that for UDRP, we need to prove that the domain name has been used and is being used in bad faith. But in .my DNDR, we only need to prove either the domain name has been used or registered in bad faith. The remedy is basically the same. We can request transfer or cancellation. And for remain, it means that the complainant failed to prove all of those elements. So today I've got 2 case studies that I want to share with all of you. So the first case is related to a recent case filed with DNDR, and the complainant is the Hong Kong Exchange and Clearing Corporation, and the respondent is a family-owned business in Hong Kong. The case could be a bit complicated if we compare to the other clear-cut UDRP cases. So, for example, back to 1999, the complainant was incorporated, and then it registered the domain name hkec, not ax.com.hk. Not long later, Mrs. Lei registered hkex.com, and it is before the complainant registered the first HKEX trademark as well as hkex.com.hk. The respondent in the next couple of years registered 2 other domain names, hkex.org, hkex.net, and then respondent's family registered 2 other companies. One is called New Books Limited in 2004, and the Time Code Limited was incorporated in 2021. And late last year, the complainant filed the captioned UDRP complaints. And we also can have a look at the history of the who is record, because in the past, we can clearly check the who is record. For example, who was the registrant and who is the current registrant. But since we got the GDPR, and which was mentioned by our panelists, Ring Dean, that the who is also infected, and even though the registrar, registrant, or the registry, they are not located in the European regions. then you can see that starting from 2018, the launch of the GDPR, the whois record has been masked. Then we cannot see the who is the actual registrant. And then after the complainant filed the UDRP complaint, and the whois was disclosed by the registrar in accordance with the UDRP procedure that showing the registrant is the newly registered company called Time Cowork Limited. So here brings some burden for the brand owners that it's not that easy to do their research like before the GDPR, and sometimes we may need to rely on the website content. But the problem is that not every single website resolves to any meaningful content. So that's why in this case that the complainant may not have idea who is the actual owner. And in some country or location that the company registry may strict the public to register to check the registration detail of the company, so that it's not that easy to do the research to know the ownership and the share of the companies if the domain name is owned by a company instead of an individual. And here are some procedure matters or preliminary findings related to case. And for this case, I'm not going to the outcome because it's not the main point. And both the complainant, the respondent, and the 3-member panel have done a very good job to prepare their document and decision. So it's not saying that whether or not it's a good complaint, good response, or good decision, but it's a matter of the facts of the case, and there are some procedure issues that may not be spotted in an ordinary UDRP proceedings. For example, consolidations. Complainants, if we can, as the complainant, that we can request to consolidate the case if there are multiple domain names, that as long as we can prove they are owned by the same group or person or under common control. Here's back to the privacy again. That is it becomes a more difficult issue for us to prove than before the GDPR. And for unsolicited supplemental findings, that in this case, the panels accepted the unsolicited supplemental findings simply because that there are some information could not be disclosed before the complainant received the official response from the respondent. So that's why the panel accepted supplemental findings from the both parties. And in the response or in the decision, because only the decision is published to the public, so I can only see the decision from the website of the ADNDRC. And there's another matter talking about the delay in filing a complaint. So if we go back to the history, that the domain name was registered in 1999, which is more than 20 years ago. And the complaint, the complaint was only brought to the center late last year. So there has been about 22 years between the domain was registered and then the complaint was filed. In the WIPO overview, which is the common consensus compiled from the previous decision, that delay in filing, or we call it lashes, is not within the UDRP policy rules or supplemental rules.
Mr. Paddy, I'm so sorry to interrupt you, but we have 4 questions that's in the Q&A pod at the moment. So could you conclude within 3 minutes?
Yep, sure.
For your slides?
I can.
Great.
Yeah, no
Thank
problem.
you so much. It's very informative, but I'm afraid time is not on our side. So
No
thank
problem,
you.
no problem.
Thank you,
Yeah,
Mr. Paddy.
I can wrap quickly. So the delay. So in this case, the delay is yes and no. It is not saying that the complainant are barred from filing a complaint, but when the panel is to decide the case, there are some consideration on reasons why the complaint was brought too late. And as to reverse domain name hijacking, the respondent also raised this point, but it's rejected because it does not match any of these mentioned points for domain name reverse domain name hijacking. So there's another case I planned to share, but it's a bit too long for me to share within the next 2 or 3 minutes. But simply speaking, that when the complainant to prepare a complaint, we need to make sure we present our case, because not every single panelist would give a second shot for refining, and most of the chance that the refining would be bothered by the res judicata, which is the legal doctrine for the same case shouldn't be decided twice if it is involved by the same parties and on the same issue. And the key takeaways here is that, as we noticed from the previous study, that the infringement trend follows the real world events. So if there's any other event, for example, the Ukraine or any other incidents, that probably there are some other spike of related domain name registration. And as the brand owner or as an internet user, we should continuously monitor the abuse of infringer. Even though you are not a brand owner, we should also pay attention to the website or social media or marketplace that you are not familiar with, or you are not sure it is a genuine one. And also there are different options to enforce your right, and you should pick your own choice and enforce your right wisely. That's basically all of my presentation. And if you got any questions, so please enter your question in the Q&A, and I'm more than happy to answer your questions. Thank you. And I will pass back the time to Yiling. Thank you.
Thank you so much, Mr. Paddy. It was very informative slides. I think you went into the details of the case from HKIAC and AIAC. So I think basically your materials are workshop materials. It's worth to explore even in a whole day in a workshop. You know, it's a lot of information there. So thank you so much. So may I also basically call all the panelists back, Ms. Radine, Mr. Dennis. And I just wanted to flag that we have questions, 4 questions so far. One question is basically from Ms. Noura Muhammad. I think her question is basically asking about the opinion of the progress of GDPR adoption in Asia. Radine, do you want to pick up this question?
Yeah, so I think what I showed in the trends are that the 8 principles of GDPR are being taken by the region and adopted into local laws, and the highlighting now of the digitalization of every economy is putting this into sharp focus. And I think we're going to continue to see these trends develop over time as personal data becomes more valuable. It's the currency. Often people say, what's the currency of our era? The currency of the era is our data, and the data is valuable. And this is why it needs to be protected. And this is why, if we're embarking on a compliance program, we need to implement it. And it's something for everybody to be aware of, because compliance affects everyone. Most data breaches are caused by human error. It's not something in the technical world. Of course, hacking remains a major threat. And I think we're going to have to continue to see this develop over time. I hope I've answered your question.
Thank you so much, Radine. Again, I think the topic that you presented on GDPR, that also requires a workshop by itself. So thanks so much for the informative slides. Okay, the second question is basically from YouTube, Councillor Karamjit. His question is, what is the process for a member state to qualify the test of adequacy or the adequacy test under the GDPR, and how do we go about it?
Yeah, so thank you. That's a great question. Going through an adequacy decision means that each country must make an application to the EU to be considered. And what the EU does, it reviews the laws in comparison with what is implemented under the GDPR. And then it goes through an evaluation process, making recommendations. And this is why, for example, if you look at the the applications, they take a number of years because they'll have consultations, recommendations, and then changes to the law. And then it has to go through this complex voting process, going to the board and then ultimately to the commission and to the member states, because they also have to value who is the good trading partners. And so this is why, you know, big countries like Japan wanted to have a lot of economic value, why they've have, you know, applied for adequacy a long time ago and they've been approved. And sometimes what we see is that the adequacy decision may even be only for part of a territory or part of what's considered. So for example, in Canada, which Two Cows has its jurisdiction, Canada is considered adequacy for businesses, but because of the limitations in the Canadian law, it doesn't cover absolutely everything. Definitely, I think it's a worthwhile embarkation because that does facilitate things for businesses. If you know you're dealing with an adequacy country, then you can have international data transfers, knowing that you're doing so in a lawful manner.
Okay, thanks, Radine. So the third question, basically from YouTube again, is also from Karanjit. And his question is, would ISO 27701 be a good foundation in fulfilling the GDPR requirements and compliance?
The ISO 2007-1 is a good implementation for data security and talk about data management. It doesn't specifically cover all the requirements of the GDPR. And if you were carrying out an audit, you would have to have additional safeguards dealing particularly with personal data. Under the BSI, the British Standards Institute, they've created a standard for implementation of data privacy, which has additional requirements. And maybe in time, we'll see that there will be an ISO certification that will encompass programs that show a compliance for GDPR, or at least of a similar method of embodying the 8 like general data protection principles.
Thank you, Radine. And this is the last question from YouTube, from Karanjit. He's asking, based on your experience, how does GDPR affects the UDRP process? And has the number of UDRP filings dropped since the GDPR came into effect?
Is that one for me, or is that one from our whole panelists?
Yeah, if the panelist wants to jump in and...
But my opinion is that the GDPR doesn't stop UDPR cases, because there's just going to be an increase because of the world being more focused in the digital sphere, and that we will see more cases going on just because of the growth of the digital lifespan, the digital world that we live in now. But maybe my panelists may have a view.
Yes, I agree. I fully agree that the GDPR does not stop case filing of the UDRP cases, because according from the statistic of ADN, DRC, AIAC, and other provider, we see the increase of domain name cases. So GDPR will not have affected the domain name case filing. That's my observation.
Yes, I also echo what other panelists mentioned, and I would say COVID is a larger pushing force rather than the GDPR as the pulling force. And I noticed that most of the UDRP providers, they have mentioned that they got a new record of case load in 2020 and 2021. So I'm not sure if this year they got a new record, but likely as long as we are now relying on the internet as much more than before, then I would expect the finding will keep increasing in the next few years.
Thank you so much, Mr. Paddy, Mr. Dennis, and Ms. Radine, for a very informative session on privacy trends and domain name dispute resolution. So basically, there are no further questions. I don't see any open questions here. It's all been answered. We do apologize for the technical hiccups at the beginning of the session, but it's a lot of information from our fellow panelists, and we will basically be, I hope you will join on to stay with us for the final session of the day, which is on exploring emerging technologies. So please join me in basically, thanking our panelists for a very informative session. There's a lot of information shared with the audience. Oh, wait, there's one more question just came up. That's from Hoi An. Her question, his or her question is on recently on some incidents on DNSSEC, causing such as .se, Sweden, Facebook's DNS incident, causing stopping operations on the internet system of those domain names. Sorry, I believe this is a technical question. So I think we will address that separately, not for this session on domain name dispute resolution. So thank you so much again, Mr. Dean, Mr. Dennis, and Mr. Paddy. So that's the end of our session, and I'll just hand over now to our Master of Ceremony, Amir. Thank you so much.
Thank you very much, everyone.
Thank you very much, everyone, for the very insightful discussion.
Thank you so much.
Okay, before we go, can you fill out the survey that will pop up in front of your screens? As for further feedback, kindly fill up the form that has been provided on the chat box, and don't forget about the Amazon gift card worth USD50 each that could be yours. For more details, you may visit apac-forum.my. The next session will be on exploring emerging technologies. We start at 16:15 p.m. in